What we're witnessing is Donald Trump watching federal marshals begin the process of taking control of his properties. And the judge overseeing the case didn't merely turn aside his legal arguments, she dismantled them piece by piece, issuing a ruling so severe that legal analysts are calling it one of the harshest opinions ever leveled against a former president. The spark for this financial unraveling came from Trump's own legal team, who filed emergency motions arguing that the asset seizures were unconstitutional, that the fraud judgment was politically driven, and that enforcing it would inflict irreparable damage on his business empire. The judge's reply was blistering. She labeled the arguments frivolous, devoid of legal merit, and an affront to the court's integrity. This goes far beyond a wealthy developer losing a few holdings. What's unfolding is the methodical stripping away of the Trump organization's most prized assets, properties that have shaped the Manhattan skyline and Trump's public persona for decades, now being inventoried, valued, and lined up for seizure to satisfy an enormous civil fraud judgment. Because once federal authorities are placing padlocks on Trump Tower and moving trucks are pulling up outside 40 Wall Street, the idea of legal accountability stops being abstract and becomes unmistakably real. It's staggering to realize that an empire built over half a century, long held up as evidence of unparalleled business brilliance, now risks collapsing because it was propped up by persistent exaggerations about what it was actually worth. Here's the background you need to understand how this escalated so quickly. The roots of this crisis trace back to New York Attorney General Letitia James and her sweeping civil fraud case against Donald Trump, his adult sons, and the Trump Organization itself. After years of investigation, James alleged that Trump routinely inflated property values when applying for loans and insurance, while sharply lowering those same valuations when tax bills came due. These weren't small bookkeeping errors. Investigators found that Trump claimed his penthouse apartment was nearly 3 times its real size, valued Mar-a-Lago at more than $500 million despite evidence it was worth far less, and manipulated appraisals across his portfolio with remarkable consistency. The case went to trial in late 2023, and Judge Arthur Engoron concluded that Trump had engaged in persistent, long-running fraud spanning decades. In February 2024, the court issued a judgment exceeding $450 million with interest and ordered the disgorgement of profits obtained through fraudulent practices. Trump appealed immediately. But this is where theory collided with reality. Under New York law, appealing a judgment doesn't stop enforcement unless the defendant posts a bond covering the full amount plus interest. In practical terms, that meant Trump needed close to $500 million in cash or highly reliable collateral to freeze the collection process. Reporting from Politico in March 2024 revealed that Trump's legal team contacted more than 30 surety companies and failed to secure a bond. The reason was straightforward. Trump's own fraud conviction had undermined the credibility of his property valuations, and no reputable financial institution was willing to accept that risk. And it's important to be clear about what this means. Asset seizures are extraordinarily rare for former presidents. They don't happen to billionaires who genuinely have the liquidity they claim. They happen when courts issue massive judgments, legal avenues are exhausted, and the debtor either cannot or does not pay. Reaching this stage says far more about Trump's real financial position than decades of branding ever did. This is where events took a dramatic turn. Multiple outlets, including CBS News and CNN legal analysts, report that the asset seizure process moved forward this week as New York State attorneys, working alongside federal marshals and court-appointed receivers, arrived at Trump properties with court orders in hand. At 40 Wall Street, the historic Manhattan skyscraper, Trump has long promoted as a cornerstone of his empire. Officials were observed entering the building to inventory assets and establish control procedures. At Seven Springs, Trump's sprawling estate in Westchester County, court-approved appraisers were granted access to conduct formal valuations. And even Trump Tower, the gold-clad Fifth Avenue landmark, synonymous with Trump's brand since the 1980s, saw legal officials begin assessing how the property could be transferred or liquidated to satisfy the judgment. Trump's lawyers threw everything they had at the wall to stop it. They rushed in emergency filings, arguing that taking control of the properties would cause irreparable damage, not just to Trump, but to tenants, businesses, and employees operating inside the buildings. They insisted the entire case was politically driven, claiming Letitia James campaigned on going after Trump and was now carrying out a personal vendetta. They also argued that enforcing the judgment before the appeals process concluded violated Trump's due process rights. NBC News reported that Trump's legal team warned of impending chaos, asserting that forced sales would depress property values, harm innocent third parties, and amount to an unconstitutional seizure by the state. The court was unmoved. In a written decision issued this week, one legal observers have described as devastating, Judge Engoron methodically addressed every argument and dismantled them one by one. CNN legal analyst Jeffrey Toobin, after reviewing the ruling, noted that the language was strikingly blunt by judicial standards. The judge emphasized that Trump was found liable for fraud after a full trial in which he was given ample opportunity to present evidence and defend himself. She made clear the judgment was no ambush. It was the foreseeable result of conduct the court had already determined to be persistent, egregious, and deliberate. On the claim of irreparable harm, the judge was especially direct. Any harm, she wrote, was entirely self-inflicted. If Trump wanted to avoid asset seizure, he could have refrained from committing fraud or posted the legally required bond to pause enforcement. His failure to secure a bond was not the court's responsibility. Then the ruling turned sharper. Addressing the political persecution argument head-on, the judge rejected the notion that New York's Attorney General, courts, and judicial system were engaged in a coordinated conspiracy against Trump. She wrote that the claim was not only unsupported by evidence, but deeply offensive to the integrity of the justice system. She underscored that Trump had received full procedural protections, that the evidence of fraud was overwhelming, and that reframing a legal defeat as political persecution was precisely the kind of bad faith argument the court had come to expect from Trump's legal team. According to MSNBC's legal correspondent, the judge essentially accused Trump of trying to weaponize the appeals process, using procedural motions not to seek justice, but to delay accountability indefinitely. This isn't the first time Trump has responded to serious legal jeopardy with the same familiar playbook. Over and over, the pattern repeats. Fight every step, cry persecution, question the legitimacy of the courts, and refuse to accept their authority. Look at how he handled the classified documents case. For months, Trump insisted the documents belonged to him, claimed he had magically declassified them, and argued the National Archives had no right to recover them. He resisted subpoenas, ignored court demands, and left the FBI with no choice but to execute a search warrant. Even after he was indicted, he framed the case as a political witch hunt, insisting former presidents could keep whatever documents they wanted. Only when criminal charges and the prospect of prison became unavoidable did the messaging shift from "I did nothing wrong" to "maybe it wasn't technically legal, but everyone does it." The same approach showed up again during the January 6th investigations. Trump argued executive privilege shielded him from testifying despite no longer being president. He sued to block the National Archives from releasing records to the House committee and urged witnesses to ignore subpoenas. When criminal charges followed, he pivoted to claiming absolute presidential immunity, asserting that anything done while in office was beyond legal scrutiny, regardless of legality. The strategy never changed: delay the process, appeal every ruling, declare the system corrupt, and hope time or politics intervenes before accountability arrives. And then there were the E. Jean Carroll defamation cases. After a jury found him liable and ordered him to pay millions, Trump immediately repeated the defamatory claims online, promptly triggering another lawsuit and another staggering judgment. Each case tells the same story: not a defense rooted in facts or law, but a cycle of denial, deflection, and escalation that only deepens the consequences. When the court required him to post a bond while appealing the judgment, Trump fought that as well, calling it excessive, politically driven, and fundamentally unfair. The pattern was unmistakable: commit the conduct, deny it outright, attack the accuser, lose in court, claim persecution, refuse to pay, and then weaponize every procedural delay available. This wasn't new behavior born in politics. Long before Trump ever ran for office, this was how he operated in business. Contractors who completed work on his properties would submit invoices only to receive lowball settlement offers or nothing at all. If they sued, Trump's legal team would stretch the cases out for years, burying smaller firms under mounting legal costs until they either settled for a fraction of what they were owed or walked away entirely. The calculation was simple: make fighting him so expensive that surrender felt like the rational choice. That tactic worked when his opponents were individual contractors or small businesses with limited resources. But now Trump is up against state attorneys general and government prosecutors with deep benches, vast resources, and no incentive to back down. Delay no longer creates leverage. Intimidation no longer works. And for perhaps the first time, Trump is experiencing what it's like when the other side can't be exhausted, outspent, or bullied into submission. So what specifically did the judge say that makes this ruling so devastating? Let's break down the key sections that have legal experts stunned. Reporters who examined the full opinion say the judge dismantled Trump's claims in three major sections. The first focused on the irreparable harm argument. Trump's lawyers argued that forcing asset sales before his appeal was resolved would cause damage that couldn't be undone if he ultimately won. The judge explained that New York's bond requirement exists precisely to balance these concerns. If Trump truly believed his appeal had merit, he could have protected his assets by posting bond. His failure to do so wasn't evidence that the rule was unfair. It was proof that financial institutions, which assess risk for a living, didn't believe his assets were worth his claimed valuations or that his appeal was likely to succeed. Here's the irony the judge highlighted. Trump was found liable for fraud because he consistently